Okay, good morning. This is J. Mark D. Bukog from BS Criminology 3 Delta for the continuation of our activity 8C. Okay, let's go to our next topic. The nature, characteristics, location, and extent of the one may be belly claim of self-defense. When the aggression runs away, the one making a defense has no more right to invoke self-defense. Number 2, reasonable necessity of the means employed to prevent or repel it. It contemplates two situations that may arise while the aggression is taking place. The first is to repel an action aggression. The second is to prevent an imminent or impending aggression. Requisites. Number 1, means were used to prevent it or repel it. Number 2, means must be necessary and there is no other way to prevent or repel it. Number 3, means must be reasonable depending on the circumstances but generally proportionate to force of the aggression. Okay? The rule here is to stand your ground when in the right, which may be invoked when the defender is unlawfully assaulted and aggressor is armed with a weapon. Where the accused is where he has the right to be. The law does not require him to retreat when assaulted, but rather to stand ground when in the right. The reasonable necessity of means employed to put up the defense. The gauge of reasonable necessity is instinct of self-preservation, exempli grotesque or example. For a person did not use his rational mind to pick a means of defense but act out of self-preservation, using the nearest or only means available to defend himself, even if such means be disproportionately advantageous or as conferred with the means of violence employed by the aggressor. Reasonableness of means depends on the nature and quality of the weapon used, physical condition, character, size, and other circumstances. Whether or not the means employed is reasonable will depend upon the place, occasion, and other circumstances. More often, it is the nature and quality of weapon used by the aggressor. It is, let's go to page 32, is also dedicated by the physical condition, size, and sex of person defending himself. Okay, let's go to next topic, the battered woman syndrome as justifying circumstances. The battered woman syndrome is characterized by a so-called circle of violence, which has three phases. Phases. Number 1, the tension building phase and manner battering occurs. Number 2, the acute battering incident characterized by brutality, destructiveness, and sometimes death. Number 3, number 3. Triangle loving praise and the woman and her batterer are emotionally depending on each other. She for his controllant behavior, he for her forgiveness. This cycle must be repeated. Okay, let's go. Let's go to next paragraph. Okay, let's take it serious. The justifying circumstances of battered woman syndrome was not applied in the case of Maribek Genosa because the accused failed to present evidence with regard to the third phase of the cycle, that she felt that she provoked the violence incident between her and her spouse, that she believed that she was not only hope for her husband to perform, that she believed that she was the sole support of his emotional stability and well-being, that she is depending on him, that she feels helpless and trapped in the relationship, that both regard death as preferable to separation. Self-defense was also not appreciated in the case of Maribek Genosa because the unlawful aggression was already ceased at the time. The accused killed her battered. Circumstances, mga exempting circumstances. Justifying, the circumstances affects the acts, not the actor. Exempting, the circumstances affects the actor, not that act. Second, justifying, the act is done within the legal bounds, hence considered as not a crime. Exempting, the act is felonious and hence a crime, but the actor acted without voluntariness. Number 3, so justifying, since the act is not a crime, there is no criminal. Exempting, although there is a crime, there is no criminal because the actor is regarded only as an instrument of the crime. Okay, let's go to next page 33. Okay, there being continuation pala. Okay, continuation. There's being no criminal, no crime nor criminal. There is no criminal nor civil liability. There's being a wrong done but no criminal. There is civil liability but no criminal liability. Avoidance of greater evil or injury in accident. Okay, justifying circumstances but the actor is civility liable. Exempting circumstances that is also exempt from civil liability. In order to avoid greater evil or injury, the actor causes damage to another. The actor causes an injury by mere accident while performing a lawful act with due care. The evil which brought about a greater evil must not result from violation of the law by the actor. The actor must be free from fault or negligence. Insane, imbecile, feebly-minded. Ano? Feeble-minded. Feebly. Okay. Insane. Has a lucid interval. Imbecile. Has no lucid interval. Although advanced in age, he has a mental development comparable to that of 2 and 7 years old. He must be completely deprived of reason, which discernment and freedom of the will at the time committing the crime. Feeble-minded, not exempted from criminal liability. In people, okay, it's not our topic. Okay, next page. Okay. Insanity was not appreciated because the accused surrendered to the authorized immediately after the incident. Such act is incontestable proof that he knew that what he was done was wrong and that he was going to be punished for it. And people, Erwin is the GR number 199875 and November 21, 2012. The defense insanity was not valid if the act of the accused of threatening the victim with death in case she reported her ravishment indicated that he was aware of the reprehensible moral depravity of that assault, that he was not deprived of intelligence. November 21, 2012, citing People versus Rafahan. That was the sources of this text. Okay. Irresistible force, the force which consists of violence or physical force coming from a third person must be irresistible, that inspired of all resistance. It reduces the actor to a mere instrument. Okay. Sa uncontrollable fear. Threat or intimidation is employed to compel another to commit a crime. The fear must be grave, actual, serious, and of such kind of that one would succumb because of the reasonable fear of one's life or limb. It must not speculative, fanciful, or remote fear. Elements of incurable cause. Number 1, that the act is required by law to be done. Number 2, that a person fails to perform such act. Number 3, that his failure to perform such act due to some lawful or insuperable cause. Number 3, let's go to number 3, last another topic. Lack of sufficient provocation on the part of the person defending himself. For provocation to perform considered serious by court, the degree must be sufficient and must at all times be immediate to unlawful aggression. When no provocation at all given to the aggression by the person defending himself, when even if provocation was given by the person defending himself, such was not sufficient to cause violent aggression on the part of the attacker. Example, the amount of provocation was not sufficient to stir the aggressor into the acts which led the accused to defend himself, when even if the provocation were sufficient, it was not given by the person defending himself. When even if provocation was given by the person defending himself, the attack was not proximate or immediate to the act of provocation. Sufficient means proportionate to the damage caused by the act and adequate to stir one to its commission. Another topic, kinds of self-defense. Mga kinds ng self-defense. Number 1, self-defense of chastity. To be entitled to complete self-defense of chastity, there must be an attempt to rape. Mere imminent thereof will suffice. Honor of a woman and respect of her defense and equitable with her virginity. That's the self-defense of chastity. Okay, let's go to number 2. Defense of property. An attack on the property must be coupled with an attack on the person of the owner or of one entrusted with care of such property. This can only be invoked if the life and limb of the person making the defense is also the subject of unlawful aggression. Life cannot be equal to property. Okay, that's it. Number 3. Self-defense and libel. Physical assault may be justified when the libel is aimed at a person's good name. And while the libel is in progress, one libel deserves another in order. However, the one may invoke this novel doctrine, the defamatory statements made by the accused must be a fair answer to the libel made by the supposed offended party and must be related to the imputation made. Defense of relative. Okay, let's go to this topic. The defense of relative elements. Number 1, unlawful aggression. Number 2, reasonable necessity of means employed to prevent or repel the attack. Number 3, in case provocation was given by the person attacked, that the person making the defense had no part in such provocation. Relative, entitled to the defense, spouse, ascendants, descendants, legitimate, natural, or adopted brothers or sisters. Number 5, relatives by affinity in the same degree, second degree. Number 6, relatives by consanguinity with the fourth civil degree. If the person being defended in early second cousin, one not invoke defense or relative anymore. If it will be defense of a stranger, this is a vital because if the person making the defense act out of revenge, resentment, or some evil motive is in killing the aggressor, he cannot invoke the justifying circumstances if the relative defended is already a stranger in the eyes of the law. On the other hand, if the relative defended is still within the coverage of defense or relative, even though he acted out of the some evil motive, it would still apply. It is enough that there was unlawful aggression against the relative defended and that the person defending would not contribute to the unlawful aggression. Mistake of fact can be basis of defending a relative. If the defender believes in good faith in evidence presented to him and acts accordingly, he is entitled to the benefits of defense or relatives, even if later on the events would actually show that they were different. Defense of stranger, its elements. Number 1, unlawful aggression. Number 2, reasonable necessity of the means. Excuse me. Number 2, reasonable necessity of the means employed to prevent or repel the attack. Number 3, the person defending be not induced by revenge, resentment, or other evil motive. A relative not included in defense or relative is included in defense of stranger. Be not induced by evil motive means even an enemy of the aggressor who comes to the defense of stranger may invoke these justifying circumstances, such long as he is not induced by motive that is evil. State of necessity, Article 11, paragraph 4 provides any person who, in order to avoid an evil or injury, does an act which causes damage to another, provided that the following requisites are present. First, requisites that the evil sought to be avoided actually exists. Second, that the injury feared be greater than to avoid it. Number 3, third, that there be no other practical and less harmful means of preventing it. This is the only justifying circumstances which provides for payment of civil indemnity. Under the other justifying circumstances, no civil liability attached. The courts shall determine in their sound discretion the proportionate amount for which one is liable. Civil liability referred to in a state of necessity and is based not on the act committed but on the benefits derived from the state of necessity, so the accused will not be civilly liable if he did not receive any benefit out of the state of necessity. On the other hand, persons who did not participate in the damage or injury would be pro tanto civilly liable if they derive benefit out of the state necessity. Fulfillment of duty or lawful exercise of a right of office or office. Elements: that the accused acted in the performance of duty or in a lawful exercise of right of office. Number 2, that the injury caused or offense committed by the necessary consequence of the due performance of duty of the lawful exercise of such right or office. A police officer is justified in shooting and killing a criminal who refused to stop when ordered to do so, and after such officer fired warning shot in the air, shooting an offender who refused to surrender is justified. But not a thief who refused to be arrested. Obedience to a superior order. Elements: there is an order. The order is for legal purpose. The means, number 3, the means used to carry out said order is lawful. Okay, let's go to another page, 38. The person giving the order must act within the limitations prescribed by the law. The subordinate taking the order must likewise act within the bounds of the law. Exempting circumstances not imputability are those grounds for exemption from punishment because there is a wanting in the agent of the crime of any of the condition which makes the act voluntary or negligence. Basis: the exemption from punishment is based on the complete absence of negligence, freedom or of action or intent, or absence of negligence on the part of the accused. A person who acts without malice, without intelligence, freedom of action or intent, or without negligence, without intelligence, freedom of action or fault is not criminally liable or is exemption from punishment. There is a crime committed but no criminal liability arises from it because of the complete absence of any condition which constitutes free will or voluntariness of the act. Burden of proof: any of the circumstances is a matter of defense and must be proved by the defendant to the satisfaction of the court. Article 12, circumstances which exempt from criminal liability. The following are exempt from criminal liability. Number 1, imbecile or insane person. unless the latter has acted during a lucid interval when the imbecile or an insane person has committed an act which the law defines as felony or delito. The court shall order his confinement is one of the hospitals or asylum established for person thus afflicted, which he shall not be permitted to live without first obtaining the permission of the same court. Number 2, person under 9 years old of age, 9 years of age. Number 3, a person over 9 years of age and under 15 unless he acted with discernment, in which case such minor shall be proceeded against in accordance with the provision of the Article 80 of the Code when such minor is judged to be criminally irresponsible. The court, in conformably with the provision of this in the preceding paragraph, shall commit him to care and custody of his family, who shall be charged his surveillance and education. Otherwise, he shall be committed to care of some institution of person mentioned in the said Article 80. Number 4, any person who, while performing a lawful act with due care, causes an injury by mere accident without fault or intention of causing it. Number 5, any person who acts under the impulsion or of irresistible force. Number 6, any person who acts under the impulse of uncontrollable fear of unequal or greater injury. Number 7, any person who fails to perform an act required by law when prevented by some lawful insurreparable cause. Number 1, another topic, an imbecile or insane person, unless the latter has acted during a lucid interval when the imbecile or insane person has committed an act which the law defines a felony or delito. The court shall order his confinement on one of the hospital or asylum established for a person thus afflicted. He shall not be permitted to live without first obtaining the permission of the same court. Requisites: A. Offender is an imbecile. Number 2, offender was insane at the time of the commission of the crime. Okay, imbecile or insanity basis: complete absence of negligence and elements of voluntariness. Definition: an imbecile is one who, while advanced in age, was a mental development incomparable to that of children between 2 to 7 years of age. An insane is one who acts with complete deprivation of intelligence, reason for without the least discernment, or with total deprivation of freedom of the will. Next paragraph, an imbecile is exempt in all cases from criminal liability. No lucid interval. The insane is not so exempt if can be shown that he acted during a lucid interval. In the latter, loss of consciousness of one's act and not mere abnormality of mental faculties will equally one's acts as those of the insane. Instance of insanity: dementia precox, schizophrenia is covered by the terms insanity because homicidal attack is common in such form of psychosis. It is characterized by a delusion that that he is being inferred with sexually, or that his property is being fixed, thus the person has no control over his act. Number 2, pletomapia or presence of abnormal persistence impulse or tendency to steal. To consider exempting will have to be investigated by competent psychiatrists to determine if the unlawful act is due to irresistible impulse produced by the mental defect. Thus, loss of willpower: if such mental defects only diminish the person of his willpower and did not deprive him of consciousness of his act, it is only mitigating. Number 3, epilepsy, which is a chronic nervous disease characterized by convulsive motion of the muscle and loss of consciousness, may be covered by the term insanity. However, it must be shown that the commission of the offense is during one of those epileptic attacks. Irresistible mindedness is not imbecility. because of the defender can distinguish right from wrong and be silent, and that insane to be exempted must not able to distinguish right and wrong. Ribola feeble-mindedness is imbecility, crimes committed while in a dream by a somnambulish are embraced in the plea of insanity. Uh, Hypnotism, however, is a debatable issue. Albert, crime committed while suffering from malignant malaria is characterized by insanity at the times, though such person is not criminal liable. Number 2, a person under 15 years of age, minority, requisites the offender is under 15 years of age at the time of the commission of the crime. There is absolute criminal irresponsibility in the case of minor under 15 years of age. Basic complete absence intelligence under 15 years to be construct 15 years of or less, such the inferred from next subsequent paragraph, which does not totally. So I can't read. Okay, that's all, sir. That's all, activity 8D. Okay, thank you so much.